talk about the importance of Hunter Biden obeying his subpoena and some of the evidence that we had questions about today when we had arranged with Hunter Biden and his attorneys for him to come in. Then he evaded his subpoena, and there's serious evidence that needs to be discussed. That has to do with many of the bank reports that we had read in the Treasury, outlining very serious crimes that Hunter Biden had committed or has allegedly committed, and then we have evidence of that. Crimes of Mann Act violation, human trafficking, these were in the bank reports, and the American people deserve to know about it. Here's another excerpt from a bank report.
Mr. Chairman, what is
talking about a victim in California.
Hold on one moment, Ms. Green. State your point, Mr. Goldman.
What is the gentle lady just showing to the cameras?
This is her 5 minutes on your amendment.
Well, if it's the suspicious activity reports, there was an agreement with the Treasury Department that the committee would not disclose the information.
It's my understanding what she's showing has already been disclosed in the public long before we started this investigation.
So this is in the public domain?
Yep.
Yeah.
Wait,
Is that your representation?
Is it a verbal representation? It's in the public domain?
This is in the public domain. I reclaim my time. Victim 1 is a California resident currently employed with FSS Management between June 2018 and October 2021. Victim 1, Hunter Biden's victim, was employed by Owasco PC as evidenced by her receipt of bi-weekly payroll remittances from Owasco PC. However, during this same period of time, victim 1 also received large round dollar wires from Owasco PC, which reference new hire, K-wage, 10K golf member, and pay. Victim 1 received 5 wires totaling $44,508 in a 4-month period between June 12, 2018 and October 2nd, 2018. These are reports that are calling so-called employees of Hunter Biden and his law firm victims. And here's evidence of Hunter Biden violating the Mann Act. This is trafficking women across state lines for prostitution. This is an airplane ticket showing that it was purchased by Hunter Biden for this victim, where she flew from Los Angeles to Washington, D.C., and then the next day flew back to Los Angeles. The date is she flew in from Los Angeles on June 14th, 2018, and was flown back to Los Angeles the following day. And this is pictures that Hunter Biden had produced and uploaded to porn websites, and it's marked out.
Mr. Chairman, point of parliamentary inquiry.
Showing proof of Mann
Okay.
Act violations. Democrats should not be offended by pictures that black out.
Have I been
things.
recognized?
They should be
Objection. I
offended
have a
by
point of
actual
parliamentary
human
inquiry.
trafficking.
Mr.
All
Chairman.
right, but state your point.
Thank you kindly, Mr. Chairman. On July 26, I sent you a letter about the last time this happened, when the gentlelady introduced before this committee, without any notice to anyone, nude photos, pornographic images that were completely irrelevant to the purpose of the hearing itself. And my question to you is, are members allowed to simply put up sensationalistic, voyeuristic, pornographic images if they're not relevant to the actual object of the legislative proceeding? I want a parliamentary ruling on that.
Mr. Askin, that's probably part of the questioning for Mr. Biden, violations of the Mann Act. Ms. Green's led on that issue.
No, this is a question about the rules of the committee.
These pictures have already been entered into the record.
So in other words, you have accepted the idea that members can introduce irrelevant, sexually based, voyeuristic...
How is this irrelevant?
Well,
How does it relate to Joe Biden?
How does it relate to...
We're not doing a criminal investigation of Hunter Biden.
We've
Point
had
of order, Mr.
several
Chairman.
people
Point of
that
order.
have testified in the FBI DOJ,
Okay.
IRS, that they were told to stand down investigating various crimes of the Biden family.
Okay.
Did Joe Biden tell them to stand down? Who told the IRS, the FBI, and everyone else to stand down? This is what we're investigating.
None of
Reclaiming my
Stop
time, Mr. Chairman.
I believe it's my time.
No,
I'm reclaiming
no,
my
I have
time.
been
All right,
I've been
stop the clock.
I
You're
object.
good.
I object to the use of this exhibit, Mr. Chairman. This is not a criminal investigation of the Mann Act or prostitution or anything else. It's completely irrelevant to a subpoena, the validity of that subpoena, and whether or not there's been compliance with that subpoena. It's totally extraneous, immaterial, and irrelevant. And someone should explain that to Ms. Green if she doesn't understand.
Point of
This is-
parliamentary
this is-
inquiry.
And let the
Capable of
chair
understanding it.
rule. You had a point of order. The chair's rule.
I
This
object
is
to the use
evidence.
of this-
You objected. We got that. Evidence that Hunter is a material witness in this investigation.
Well, does
Now-
that mean you can put up pornographic pictures of other people that Hunter Biden has met in his life? I mean, come on. Like, how far does that go? It's not relevant to your motion.
Well, you can ask him that in the
It's
deposition.
not relevant. No, honestly, Mr. Chairman, it's not relevant to your motion of whether or not he violated that subpoena. How did those naked pictures have anything to
Mr.
do with
Chairman,
it?
point of order.
This is not the Jerry Springer
That's your
show.
point.
This is the United States House of Representatives.
And let me
Come
say
on.
this.
Talked
Let me
about a
say
bunch of
this.
things
It's
today
not
that weren't
pornography. It's appropriately censored evidence in an ongoing investigation.
Yes.
Okay? It's appropriately censored evidence in an ongoing investigation.
Censored-
Mr.
All right, I
Biggs
just want to
raised
say,
a point.
pursuant to Clause 6 of Rule 17, I object to the use of this exhibit as irrelevant, extraneous, sensationalistic, voyeuristic, and totally antithetical to the legislative purposes of this committee and this House. This is not the Jerry Springer show. Yield back.
Chair recognizes Mr. Biggs for a point of order.
Thank-
We're
thank-
still, your clock stopped, Ms. Green.
Yeah, my point of order is to
And I appeal the ruling of the chair. If that was a ruling, Mr. Chairman, did you rule on it? Because I appeal your ruling. If you're-
so I was recognized for my point of order,
ahead.
and I get it. He wants to have an appeal. So, but
Chair
I'm trying to keep this in order as much as we can. Mr. Chairman, my question is to you: is now the objection based on relevance going to be encountered here and constrain what can be presented in this committee? And the reason I ask that is because there is virtually nothing. A comment I made in the press about it was totally tangential to this, that they just tried to get in. All of that becomes irrelevant. If that's the case, then the entire Democrat testimony that we've heard today should be stricken as being irrelevant.
No, I think you're,
irrelevant and
we're going
pornographic.
to have a ruling. So Ms. Green is attempting to enter this into the record, unanimous consent. Mr. Raskins has objected. Objected, and we're going to vote on it, just like we voted on the last amendment.
Clearly. They defend all women, don't they? Except women
Yeah,
that Hunter Biden
the ruling is the point of order will not be recognized, and Ms. Green is in order. If you want to object.
Well, yeah, I object. And Mr. Chairman, you have the authority to bring to the full House under Rule 17 whether or not pornographic material should be entered
And
without
again,
a clear
it's
showing of
not
relevance. And I would ask you to
Mr.
bring that to
Chairman.
the floor of the House. Let the members of the House decide whether that's the new standard, whether the
Mr.
Congressman
Chairman,
Marjorie
may I
Taylor
have
Greene's
my-
standard is going to be
may
the
I
standard for
reclaim
the whole
my
House.
time?
The quorum is within discretion of the chair. We've overruled your objection.
And I appeal that.
You appeal the ruling of the chair.
Yes, I do. I would like to
We're
vote.
going to vote on that.
We're going to vote on the pornography.
May I finish?
Hold on. All right, Mr. Gosar, you're recognized.
I move to table the motion.
Okay. Motion to table the motion that, of Mr. Raskins. This motion is not debatable. As many as are in favor of tabling signify by saying aye. Aye. All those opposed signify by saying no.
No.
In the opinion of the chair, the yeas and the motion, the yeas have it, and the motion to table is agreed to. The committee will now resume.
Mr. Chairman, I would move for a recorded vote. I mean, if that were a book, she would censor it, but she wants to advertise it through the House of
Recorded vote
Representatives.
is ordered. A recorded vote is ordered.
If we're going courtroom, speaking objections don't work, Chief.
The clerk will call the roll. You'll call the roll. If you vote yes, you table the motion. So, clerk, call the roll.
Mr. Jordan. Mr. Turner. Mr. Gosar. Mr. Gosar votes yes. Ms. Fox. Ms. Fox votes yes. Mr. Grothman. Mr. Grothman votes yes. Mr. Cloud. Mr. Cloud votes yes. Mr. Palmer. Mr. Palmer votes aye. Mr. Higgins. Mr. Higgins votes aye. Mr. Sessions. Mr. Sessions votes aye. Mr. Biggs. Mr. Biggs votes aye. Ms. Mace. Mr. LaTurner. Mr. LaTurner votes aye. Mr. Fallon. Mr. Fallon votes aye. Mr. Donalds. Mr. Donalds votes yes. Mr. Perry. Mr. Perry votes aye. Mr. Timmons. Mr. Timmons votes aye. Mr. Burchett. Mr. Burchett votes aye. Ms. Green.
Aye.
Ms. Green votes aye. Ms. McLean. Ms. McLean votes aye. Ms. Boebert. Mr. Fry. Mr. Fry votes aye. Ms. Luna. Ms. Luna votes aye. Mr. Langworthy. Mr. Burleson. Mr. Burleson votes aye. Mr. Waltz. Mr. Waltz votes aye. Mr. Raskin.
No.
Mr. Raskin votes no. Ms. Norton.
No.
Ms. Norton votes no. Mr. Lynch. Mr. Lynch votes no. Mr. Connolly. Mr. Connolly votes no. Mr. Krishnamurthy. Mr. Khanna. Mr. Khanna votes no. Mr. Mfume. Ms. Ocasio-Cortez. Ms. Porter. Ms. Porter votes no. Ms. Bush. Ms. Bush votes no. Mr. Gomez. Ms. Brown. Ms. Stansbury. Mr. Garcia. Mr. Garcia votes no. Mr. Frost. Mr. Frost votes no. Mr. Kassar. Ms. Lee. Ms. Lee votes no. Mr. Kassar votes no. Ms. Crockett.
No.
Ms. Crockett votes no. Mr. Goldman. Mr. Goldman votes nay. Mr. Moskowitz. Mr. Moskowitz votes no. Ms. Tlaib. Ms. Tlaib votes no. Mr. Chairman.
Chairman votes yes.
Mr. Chairman votes yes.
Will the clerk please report the tally? Okay.
Mr. Chairman, on this vote, the nays are 15, the ayes are 21.
The yeas have it, and the motion to table is agreed to. The committee will now resume consideration of the Goldman Amendment. Ms. Green has 2 minutes remaining.
Thank you, Mr. Chairman. And again, this information is extremely important because Hunter Biden refused to obey his subpoena, and we are holding him in contempt of Congress for doing so. This is important evidence of human trafficking, Mann Act violations that we had questions for the president's son about. And there's evidence. I'd like to show the evidence of payments. These are payments made from Hunter Biden and his law firm to so-called assistants. These were not assistants. These are prostitutes that he was trafficking. And I think these victims are important. And just because our Democrat colleagues don't like the evidence doesn't mean that it's not relevant. And I'm especially offended by the women on this committee that don't care about these women's rights. They're victims of Hunter Biden. Here's another excerpt from bank reports talking about victims. These are banks, and these banks are identifying these women as victims. Victim 2. Talking about victim 2, victim 1, each appear to be in the adult entertainment industry and are receiving payments from Hunter and Owasco PC. It is unclear what relationship Hunter or Owasco PC have with these individuals. And based on public media, it appears possible the payments may be associated to prostitution or adult entertainment services. Victim 2 is a New York resident and employed as freelance. Per internet research, she is a social media influencer and adult entertainer. She received 6 quick pays for $6,250 from Hunter between 3/29/2018 and 11/20/2018. This is clear evidence, Mr. Chairman. These are important questions we have for the president's son pertaining to Mann Act violations. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Members, we should be voting down this amendment. It is not needed. What is clear is that the only document that matters is the fact that there was a subpoena issued by this committee, signed by the clerk of the House of Representatives. That is the only thing that governs subpoenas before anybody coming to this committee. It does not matter if any member of this committee did an interview anyplace, whether it's the chairman or any other member. That is irrelevant. The only thing that matters is a signed subpoena by the chairman of this committee and the clerk of the House. The semantics about what Hunter Biden thought he could do or what Abby Lowell, his attorney, tried to get him to be able to posture or get out of it is meaningless. And the Democrats know this is meaningless. This is a subterfuge because their guy bucked a subpoena against the law. Period. Full stop. Members, vote down this amendment. I yield back.
The question is on the amendment, on the Goldman amendment.
So
All those in favor of,
wait, we have another.
what's that?
We have another.
Ms. Norton, did you want to?
I yield 5 minutes to the gentleman
From New York.
from New York.
Thank you. Appreciate my distinguished colleague from D.C. I want to just take this opportunity to address some of the chairman's evidentiary allegations that you made earlier today. First, I would just note that we keep hearing this over and over and over again, that Donald Trump had a business, Donald Trump had real estate, Donald Trump, sold widgets or whatever it is. Obviously, there are many different ways of investing or spending money or getting paid for services or for simply putting capital into another company. So I don't know what these investments were that Hunter Biden and Devon Archer and these other folks were involved in. Devon Archer testified that it was private equity. That's a legitimate form of business to invest capital in other companies.
Don't you believe we should get that question under oath?
You got it under oath from Devon Archer, sir. In any event, let's go back to I think the fourth bank memorandum is what you pointed me to earlier today, because you alleged, Mr. Chairman, that there is money that went directly from CEFC, a Chinese company, to Hunter Biden, then to Joe Biden in $40,000.
Through the shells, yes.
Oh, through the shells. You didn't say that. That you didn't say. So I went back.
Well, you've had a hard time understanding what a shell company is, but anyway, go ahead.
Well, you would know, wouldn't you?
Oh, yeah.
So
That's right.
Here we are looking at this Fourth Amendment. We have, well, I'll show this chart first because it shows how clear it is. You've got Chinese company going to Biden-China joint venture, going to a Hunter Biden individual entity, going to James and Sarah Biden entity, going to James and Sarah Biden personal bank account, going to Joe Biden. So that, I guess, is what is directly money from China to Joe Biden. It just had to go from a Chinese company to a joint venture that Hunter Biden entered into with another Chinese company.
Would you yield the question?
I just want to finish going through what you told me to go through, and then I'm happy to yield. Then it went to Hunter Biden's personal company that he generally used for a variety of his business ventures. Then it went to another entity for James and Sarah Biden. Then it went to James and Sarah Biden. Then Jim Biden, almost a month later, sent a $40,000 check to his brother, the president, which said was for a loan repayment, and the same bank records where you got this from showed that a loan went from Joe Biden to Jim Biden.
That's not true.
So this is the kind of duplicity that we're talking about. You want to say there's evidence connecting Joe Biden to Hunter Biden's business ventures, and you make a false and inflammatory allegation that money went from China to Hunter to Joe, when in reality, it's 4 pages, it's 21 bullet points of information to get from A to B to C to D to E to F. There's no possible way that you could ever show that Jim Biden knows. This is my time, Mr. Chairman. There is no possible way Jim Biden you could ever prove under any circumstances that Jim Biden knew where that money came from. And you certainly cannot show with any evidence at all that Joe Biden would know that 1 month before, 6 different transactions earlier, somehow this money came from a Chinese investment that Hunter Biden had. You are desperate. You are misrepresenting the facts. There is no evidence. There's no evidence of Joe Biden's involvement in Hunter Biden's business interests. There's no evidence of Joe Biden's involvement in any Mann Act or prostitution stuff. Hunter Biden should be investigated by the Department of Justice, and he has been for 5 years. He is a private citizen. This is what you call an impeachment investigation into the President of the United States based on complete fiction and smoke and mirrors. There isn't a piece of evidence that links anything that Hunter Biden did to Joe Biden, and this is a complete sham.
Your time's expired, and those accounts that they went through were depleted. It wasn't hard to trace the money.
Mr. Chairman, may I respond, since my friend from Pennsylvania directly addressed me, and I'm happy to have this conversation to compare the 2019 impeachment investigation. Why are you leaving, Mr. Perry? I'm happy to have the conversation, because what you saw in that investigation was 17 fact witnesses who came in and testified under oath, and then 12 of them appeared in a public hearing. There wasn't a single thing that any Democratic member of Congress said that was not supported by neutral Trump administration fact witnesses and what their testimony and their documents said. Contrast that with what we have here. We haven't had a single public hearing with a single fact witness. Not one. The only public hearing we had was a complete debacle where the Republicans' own witnesses said that there is nothing approximating an impeachable offense here. So we're done. We're not having anything out in the public. And you haven't even released the transcripts of all of the depositions. When we had our first impeachment hearing with the constitutional law professors, and I would note, I at least admire your fellow colleagues on the Homeland Security Committee, which I also sit, they didn't even bother to bring in any constitutional law or impeachment experts in their first impeachment hearing today. At least they learned from the debacle that was yours. But at that hearing, we moved to have your own fact witnesses come here and testify in public as part of the impeachment inquiry. And you voted it down. You voted it down. So if you want to compare 2019, that's fine. Let's do it. Because every single fact that was in a 300-page report was not spoken by counsel, me, by Adam Schiff, the chairman of the Intelligence Committee, by any member of the Democratic Committee, of the Democratic Party. It was testimony from witnesses who had knowledge, who actually had expertise and experience and factual information about the topic at hand. We don't have that here. And when we have a witness who is willing to come and sit here and give you the evidence that you claim you want to have, you say no. You say no. You understand the accommodation process and how that works in Congress. That means that Congress issues a subpoena, and the receiving party works with Congress to accommodate the interest of both parties so that Congress can get what it needs and the interest of the witness can also be served. Hunter Biden's attorney has done that. He has agreed to every single thing in your subpoena. Every single thing, under oath, any questions you want, any topic you want, any date you want. He will not raise privileges available to him under the Fifth Amendment. He will answer your questions. The one accommodation he wants is to do it in public in front of the American people, and you are too afraid to let him do that, and I'll yield the remainder of the time to Mr. Raskin.
Now, Chair's going to recognize, Mr. Raskin will have a minute and 3 seconds. The Chair's going to recognize Mr. Gosar. I just have to throw in, you must have been absent when the IRS whistleblowers testified with respect to the number of crimes and evidence that the IRS had on the person who we're voting to hold in contempt today. You remember that hearing?
Being
Chair recognizes Mr.
by the
Gosar.
Department of Justice because
Chair recognizes Mr. Gosar.
I will tell you, the gentleman from New York has got some facts wrong. You know, when we were talking to these witnesses, these constitutionals, Jonathan Turley, they said they rose to the occasion of impeachment. But they said there was a suspicion. And that's what the impeachment inquiry was all about, to go get that information, if there is. They all said that there was a suspicion based on these shell corporations. So they did say that. They didn't say what you just said. You mischaracterized that. So, you know, from that standpoint, we got to be very, very careful with how we're cherry picking this information. Maybe we do it, but you do it too. And you did it right there. Because they did not have.
Will the gentleman yield for a question?
I'll give you a
quick question. What I said is, and I just want to make sure we're on the same. I said that the witness testified that there was insufficient evidence to impeach Joe Biden.
It was an impeachment inquiry hearing.
No.
It was he said there was more than enough evidence to proceed with the impeachment inquiry. That's what we're doing. Let's be
but
clear
did he
about
also
what we're
say
doing
that there
here.
was insufficient evidence?
Mr. Gosar's time.
No.
He said both. He said both.
You know, and when we're comparing apples to apples on the two impeachments of Mr. Trump, you didn't even go through an impeachment inquiry. You didn't even vote on the floor on one of those. So if you're talking about apples and apples, we're not even close to that. You know, the one thing I thought was the lady justice is blindfolded. She's got the scales. You put the information in there, and she's going to give you a result. She's blindfolded. She doesn't see who that is. You know, Trey Gowdy made that comment. We're missing the point here, is that the information that we got is from factual based. There's information there that is suspicious. Why would you stack all these shell companies up? You got the IRS folks that said this were whistleblowers. They didn't exonerate. I got to tell you, they are not liars. They're not liars. They do one thing, they're good at auditing. So I think what we do is we got to get back to the order of business. That is Hunter Biden violated the context of the subpoena. You know, he's not above the rule of law, so we ought to be just continuing that vote. I yield.
Right. Now, Mr. Raskins has a minute and 3 seconds.
Yep. First, to my friend, Mr. Gosar, we did not launch an impeachment inquiry for the second impeachment because Donald Trump tried to overthrow the Constitution on January 6th, 2 weeks before he left office, and we were the targets of that impeachable offense. So we all saw it. We were the witnesses, and we were the ones to vote on it, and we didn't quite have time for all of those niceties, but all of us knew exactly what happened. Secondly, I am sorry that Mr. Perry left the room at Josh Hawley's speed when Mr. Goldman began to speak there, because he made two really important points. One was he said that if you get a subpoena, you comply with the subpoena, you answer it. Yes, I would like to tell him, Mr. Perry, you comply with your subpoena, but no, he decided to arrogate the law to himself and to claim that the January 6th committee was invalid, it was illegal, it was unconstitutional. All claims that were rejected by federal courts. They do not have a single case authority for that at all. And yet he's going to now lecture other people about complying with subpoena. I mean, he should, I think, delegate some of his time to some other members to speak on that. It's a little uncomfortable there. And finally, I'm sorry?
The gentleman.
Yes, yes, go ahead.
Will allude to good process builds good policy, builds good politics. Would you agree?
Yes, I totally agree.
You don't skip, in the severity of impeachment, you never skip that process. But you did.
Donald Trump was already arguing that he couldn't be tried because it was too late at that point.
Okay.
He was already arguing.
All right, your all's 10 minutes has expired. Mr. Fallon, I think we have a minute and a half.
Thank you, Mr. Chairman. What this has devolved into is deny, 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 counter accuse. It's an old adage, and it's unfortunate.